Thank you also for inviting me. And if you hadn't seen it, by the way, there's a quite good short analysis on today's Times newspaper about the move to deregulate payments. So you might want to look at that after. I practice at the bar a lot in disputes in sport and football in particular, and therefore have over the past 14 years practiced a lot in disputes involving football agents and transactions. And both disputes, commercial disputes between agents and clubs, and agents and players, and agents against agents, and so on, and also the regulatory disciplinary disputes that often arise. And I share the views that have been expressed broadly across the panel so far, albeit I don't agree with what's said about the 3% cap, but I share the views broadly about the move by FIFA being a retrograde step to deregister, to deregulate largely this activity. But my main thesis in this talk and in the paper I circulated is that the consequence of what FIFA's doing and of what the FA is doing, which is certainly to have a slightly higher standard of regulation, the consequence of that is that there will be a significant and substantial increase in disputes and conflicts over the next year or two, or perhaps longer. And by that I mean conflicts between the parties, between intermediaries and clubs and players, between intermediaries as between themselves, and regulatory disciplinary conflicts. And I want to just focus on why I say that will be the case and where I think those conflicts. Question then, for us in England in any event, is the extent to which there will be some remaining regulation of and jurisdiction over intermediaries. Because as Bobby said, the initial idea was to get rid of all regulation or jurisdiction over intermediaries at all. That has been somewhat improved and watered down by FIFA. In England, it's a different situation. And I think in England, to a certain extent, when you actually analyse what's going to happen, we will end up with a system of soft licensing, which might not be quite as different as what we had before. It won't be as good, but it won't be as substantially different as perhaps people think. And why is that? Firstly, of course, intermediaries will still have to register with the FA. And the FA, although it has a particularly low threshold for registration, there's no exam, and we expect the test to be much lower. Nevertheless, they have to register every year, and the FA can refuse registration. So that in itself implies some control. Secondly, in relation to the registration, and this is another area where there will be a problem, for the first time now, companies are able to register and act as intermediaries. So, for example, a football agency which employs 30 registered intermediaries, that company itself can be a registered intermediary under the rules. And that seems to me to create a lot of potential problems. If, for example, the player has an agreement with the company, which would be allowed, the representation contract could be between player and company, then what's the player's rights to have any particular individual look after him? Doesn't have any under that contract. So that is bound to create particular problems and also increase conflicts. The next point is the FA regulations in any event, and I put in the paper the various references to the regulations, provide that a breach of the regulations will be treated as misconduct under the FA rules. That doesn't actually answer the question whether the FA has jurisdiction over intermediaries, because of course it could be the clubs or players who are punished for the breach. But the FA has strongly indicated in discussions with agents and others that they are going to move towards making intermediaries participants, with a big P. And that's important because the FA exercises its jurisdiction over people by making them participants under the rules. And if you are a participant, you comply with the rules of the FA, and the FA has jurisdiction over you. I believe it's inevitable the FA will, I think as early as May, at their next meeting, make intermediaries participants, and that will finally answer the question about whether the FA will have jurisdiction over them or not. And the other question that flows from that is arbitration, because at the moment, if there is a dispute between an agent and a player, or an agent and a club over a commission fee, or anything else between them related to the representation contract, they cannot sue in the court. They must sue by way of Rule K arbitration. That, I believe, will be the same in the future, because intermediaries will be made participants and therefore will continue in England, but it won't be the case in a number of other countries, to have these disputes resolved by arbitration. All of that means that when one looks at it, we will have in England more of a soft licensing system. You'll have to register, your registration will mean you're complying with the rules. If you breach the rules, the FA will have the opportunity to suspend or withdraw the registration, and you will have to submit to arbitration. And if that is the case, then obviously, under English law, which shall apply, and particularly the McInnes and Onslow Fane case, along with obligations will come rights. And those rights will be layered, as they were in that case, so that if someone is to apply for registration, their rights will be at the lower end of the threshold, but there is still a duty on the FA to consider the application in a non-capricious way. But if someone already has registration and they're threatened with it being withdrawn, then that will be very similar to the position now where they're threatened with having a license withdrawn, and they will have to have the rights of a fair hearing and all those other procedural safeguards and so on. So that's the first issue. The second is price fixing, the 3% recommended cap. I'm involved with the Association of Football Agents in pursuing the complaint to the European Commission against the recommended 3% cap. And precisely because of that, I can't speak in any detail about it, other than to inform you that the dispute is still alive and before the Commission. But what's interesting is, although the FA have chosen to incorporate the wording of the FIFA 3% cap in its regulations, the indications the FA is giving at the moment is that it's doing this because it feels constrained to do so by FIFA, and it is not going to promote the 3% cap. For instance, a key question will be, if the FA issues a standard representation contract for intermediaries, will it have, we recommend 3% in the contract? Because if it does, that will be really pushing the 3%, because the parties will see it. We expect the FA will not do that, but they may do that. There's clearly an argument about it, and Bob is on one side and many of the agents are on the other. My own view is that one needs to go back to what FIFA said when they first were required to justify the regulation of football agents in the Piau case before the European Court of Justice. And in that case, FIFA said the justification in European law for regulation of agents is to raise the professional and ethical standards for the occupation of players' agent in order to protect players who have a short career. And for me, that same justification applies when you're looking at remuneration. Because the point is, if an agent is able to charge whatever the agent and player agree, then the market is determining matters, but that is incentivizing the agent to act in the best interests of the player who has a short career. And if the parties agree it's 5% or 10%, I remember once representing a Premier League football player, and a more junior solicitor who was with me said to that solicitor, why is it some other famous solicitor pays 20% to his agent, and some other famous footballer pays 20% to his agent, considering how much that player earns, when he could get someone for 5%. And the player I was with said, well, if I had that agent and I had the wages that player had, I'd be very happy to pay 20%, because that agent had managed to pull off some of the best wages in England for the player in question. And so the parties should be free to determine that. We are yet to see the extent to which the FA will promote 3% in England, but if the FA do promote it in such a way as you're effectively having the clubs ganging together and forcing 3% on intermediaries, then there will be challenges under competition law in England as well as in Europe. The next important question where there will be legal disputes is in relation to the length of representation contracts and young players. And that's because, as previous speakers have said, FIFA no longer provides for any maximum contract period. I certainly think that that is a mistake, and I agree with the FA's approach of having a 2-year period. FIFA also says that contracts can be entered into with minors of any age, so long as it's allowed within national law and there is whatever guardian parental consent that is required in that national law, and so long as the intermediary cannot be paid until the player is 18. That creates a number of difficulties, and the two things together create a number of problems and potential restraint of trade, because the danger is very young players, including schoolboy players, being picked up by intermediaries who may well take the risk of signing up 10 or 11 of them in the hope that one will succeed in 10 years' time, to long contracts where the players have very little bargaining power and very little rights under those contracts. And although the intermediary cannot claim anything, as soon as a player turns 18 and the one that's successful is able to get a big contract, that player is still bound to the intermediary with the long contract. And it's similar to the kind of cases you used to have in England, where you had young want-to-be pop stars signing up to record companies, signing their life away, and having eventually to go to court using restraint of trade principles to be released from those agreements. So this seems to me to be a recipe for serious problems. And also one that is actually worse than third-party ownership. Like Jan Batista, I think that FIFA are wrong to get rid of third-party ownership or third-party investment, because there are some real advantages to third-party investment in football. The problem, the vice with third-party investment that people are concerned about is third-party influence. And third-party influence is a serious problem and does need to be dealt with. But what FIFA are doing here is opening the door to third-party influence, because they're saying that an intermediary can invest in a young player, same as third-party investors. The intermediary is then only able to have a return on that investment when there is some kind of transaction in the future, same as third-party investors. The difference is the intermediary will have a direct influence on that transaction, because he'll be advising on it and he'll be negotiating it. So you're actually putting third-party influence directly into football at the same time as abolishing third-party ownership. The FA's system, on the other hand, provides for a maximum of 2 years and says that intermediaries can only approach and represent players when they are aged 16 upwards. That is, in my view, a more sensible system of regulation. What isn't is the idea that an intermediary cannot be paid with respect to deals for 17-year-olds. This seems to make no sense to me, because a 17-year-old player is allowed to sign a professional contract with a club, and a 17-year-old player is allowed to sign a representation agreement with an intermediary or an agent before. And yet, the 17-year-old player is not able to use the agent or intermediary to negotiate the deal with the club unless the intermediary agrees to do so for no commission at all. How does that make sense? It seems to me to actually put the club in a stronger bargaining position as against the 17-year-old player than if the 17-year-old player had the proper use of an intermediary. Because of these rules, there will be disputes with foreign intermediaries who may come over to England, and one question I ask in the paper is what happens if a foreign intermediary has a 15-year agreement with a young player entered into before they were 18. They're now 18, they're able to do a deal in England. The English FA, I believe, would insist that the player signs a new 2-year representation contract with the foreign intermediary in England in order for the foreign intermediary to be paid. What if the player refuses? The foreign intermediary wouldn't be able to be paid, and perhaps any English intermediary who entered into a deal would, but the foreign intermediary would then have a cause of action against the player. So there are these recipes for conflicts as well. I think it's been touched upon that there is going to be a greater duty of disclosure in the approach of both FIFA and the FA in their regulations, including the possibility of lists of not only the intermediaries but of payments made to intermediaries being made more public and being published. And that is probably something to be welcomed, that transparency. I think the way that will be used and the way we'll see more conflicts in this area and disputes in this area is where there is non-disclosure. Because certainly in my experience of representing agents who are disciplined before the FA, one of the ways the FA does it, and one of the ways I think the FA will do it under the intermediaries regulations, is to say, well, we might not have enough evidence here to prove there is some kind of wrongdoing, but there has been non-disclosure of something. There's been non-disclosure of a potential conflict. And that in itself is misconduct, so you'll be charged for that. And so I think you'll probably see a big increase in those kinds of cases because of the increase on the disclosure obligations. I've also mentioned there the Jack case, and I discuss it in the footnote. It's important because there have been a large number of Rule K arbitrations I've been involved in where I've been able to get the player out of having to pay any commission whatsoever to his agent because we've been able to prove the agent has breached his fiduciary duty to the player by, for example, receiving a secret profit from the club or something of that type, which was exactly what happened in the Jack case. And I just make the point that although the Jack case is all about fiduciary relationships and agents, the case will still apply in exactly the same way to intermediaries. Just because the FA has decided to change the name of an agent to an intermediary doesn't mean that the principles of law and the fiduciary duties that will exist will alter. Tapping up and poaching is another area in which I think we will see an increase in disputes and litigation, and that is because unlike the previous regulations, both FIFA and the FA will now allow for players under contract with a club to be approached by other agents and for intermediaries to approach players who are already under contract with other intermediaries. So in the past, if you were an agent and you tried to poach a player from another agent, which we know does go on all the time, but if that happened, then the agent with the representation contract could at least say, hey, hands off, I've got a representation contract, you do that again and I'll report you to the FA. So it's some protection. That's now gone. The agent can't say that, the intermediary can't say that because there's nothing to prevent it. So there will be more of it. There will be more of it because there will be new intermediaries coming in who don't have any clients and don't have any representation contracts. So of course there will be more of it. There will be more poaching and tapping up. Again, though, just because the regulations have changed and one can't use the regulations to prevent it, doesn't mean you can't use the law, and the normal principles of breach of contract and inducement to breach of contract will apply just in the same way as they would if there was some regulatory breach. Finally, there's the issue of the way in which the market will work. And my view is that those, and I think from hearing the other speakers, this is probably a shared view, those who are already established as licensed agents, and in particular those who are successful and have the bigger businesses as licensed agents, are likely, strongly likely, to continue to dominate the market, at least in England, despite all of these changes. And that's for a number of reasons. There should not be any problem with them registering. There is this requirement that you will have seen, no doubt, to resubmit registration contracts, which I have to say is absurd, and I don't believe will be properly met in practice. What it is, if you're not familiar with it, is that if you are an existing agent with, say, 20 representation contracts with 20 players and maybe a few more dual representation contracts, you can continue those representation contracts if they were entered into last year for 2 years. You can continue them under the new system, but you have to re-register them. And you have to re-register all of them within 10 days of registering as an intermediary. So you have to resubmit all 20 or 30 contracts that the FA already have in their offices back to them in order for them to be recognised. And certainly the Association of Football Agents, who I regularly advise, are taking the stand at the moment of advising their agents not to do that, but to simply issue a letter saying, we, by this letter, formally resubmit all the documents you previously have. And legally, I think that ought to stand up. There's a question of professional liability insurance that I understand the FA are looking at. And then there's self-regulation, which has been touched upon and is also discussed in that Times article I mentioned. And I think certainly in England, but also across Europe, in Germany and other countries, there will be moves to have a kite mark system, which will be provided to people who were formerly licensed agents, perhaps people who will be required to have professional indemnity insurance, people who have a record and experience of acting as football agents, and that will be provided by their associations, like the Association of Football Agents. So it will be a form of self-regulation. And it won't be mandatory for clubs to use people with a kite mark. They can choose whoever they want, but hopefully players, and hopefully the PFA and the AFA can work together, and football clubs will advise their clients to use those who have that experience, who have insurance. So you want to have someone with insurance if you have to end up suing them, who have a track record, who have a membership of a professional body and so on. And that's another reason why I think the established agents will continue to dominate the market. And of course the last reason is that what this business is all about, ultimately, whatever anybody says about it, is market connections and expertise. The number of people I meet who think that being a football agent is an easy job because they've heard that all you need to do is make a few phone calls and you earn £1 million is remarkable. But anybody involved in the business from any side knows that that is not how it works. And just because a lot of people suddenly register as intermediaries, just as in the past many people registered as lawyers thinking that they would be able to carry out deals, doesn't mean they'll actually do any business. Those who have established themselves in the market because of their connections and expertise will. So in conclusion, my view is that we are going to see, and this is another one of the negative fallouts generally for football. It's quite positive for those like me who practice in this area, but for football it's not a good thing. We're going to see an increase, a significant increase in disputes between players and clubs and intermediaries and disciplinary disputes as a result of this deregulation and the difference between the different regulations that will now exist. Thank you.